legislative continuances. How many of
Oh,
y'all,
yes. That's the
how
title
many,
of the show.
how many of y'all are familiar with legislative continuances?
Do you even know what those are? Honestly, I didn't know this was a thing till I read this lawsuit.
Well, let me ask you this. Did you know that if you were a legislator and you committed a crime and you were like, if you'll go down to the very bottom of that section, and I've got a link, item 8 and 9. Did you know that if you committed a crime and were subject to be arrested, yep, that you couldn't be arrested? That you
Wait,
are you have privilege as being a legislator and you couldn't even be arrested? Did you know that?
uh, I want to say I did know it, but I'd be lying.
Well, scroll down to I think it's number 8 or 9. I think it's number 8. And then hone in real close to that for everybody. I want everybody to look close at this. I want you all to understand kind of what we're
Privileges and immunities. Hmm.
yeah, number 8 right there.
Shall
So
I read it?
go ahead, read it to everybody.
Section number 8. A member of the legislature shall be privileged from arrest, except for felony, during his attendance at sessions and committee meetings of his House, and while going to and from them. No member shall be questioned elsewhere for any speech in either House. Hmm. Except for felonies,
So
though. You commit a felony, I guess you can still be listed.
now, Paul Johnson, I don't know for a fact. It's interesting that you write that because somebody posed that question to me that if you were, let's say, a legislator up here from Northwest Louisiana and you decided you were late getting down to session and you hooked it up to about 100 plus miles per hour and you got pulled over, could they write you a ticket? I got to tell you, somebody conveyed to me that this law would enable you to not get a speeding ticket for hooking it up down the interstate to get to the legislative session.
Hmm. Why don't we
That you'd
get
be exempt.
somebody? Maybe we should, let's see, what's our senator's name? Oh, that fishing guy, Adam Bass. Maybe we should get Adam Bass to test that theory. Next time
He
he's headed
really,
down there, he could rip it down I-49 at about a buck 50,
he really likes fishing for bass,
does he?
sea bass. That is.
Sea bass, yes. Adam Sea Bass.
He does like fishing for sea bass. He does.
All right. Conflicts of interest.
Well, that yeah. Well, anyway, us not get off on a rabbit. Let's go back to the top. So,
Okay.
back on point here. Legislative continuances. Now, to all the lawyers out there, y'all all know that. Look, we're just regular guys. Again, my credentials are Rhodes Scholar of Stupidville. I don't know about Rex. He comes from Ruston. They got a
Hey,
whole different credentialing thing over there.
I can Google really well with the best of them.
It's I mean, go to Ruston Rants to get your answer. That's all I can say. I don't know. But let's go to cut RS 1870. And
Cut.
the subject matter to which we're going to talk about here, it's not something that just happened yesterday. This is something that's been around a long freaking time.
All right, hold on. So I've got I don't think we had the cut's not actually in there. Give me just a second. So it's LARS
No, no, no,
1870.
no. It's in the folder. They're all in the folder, and that's the name of them.
Is it in that folder?
Yes.
Oh, okay, I got it. Sorry. Oh,
Yep.
well, this
Yep.
is
Yep.
going to be fun. All right, hold on
Yeah.
just a second. So I'm going to do
See,
this. I'm going to do
burnishing our
this.
amateur credentials here.
Hey,
So,
it's a live show.
wanted to share with you guys just how old the subject matter to which we're talking about here goes. And if I recall correctly, and if you scroll down through here, what is
Hmm.
that? What does that number there at the bottom right there say?
I got to squint a little bit, but it looks like 1870, just after the Civil War. That must have been during, what's that? Oh, Reconstruction.
Yeah. So this legislative continuance law for attorneys dates back to the 1800s. It's been on the books for a long, long, long time. So the fact that the Louisiana State Supreme Court is even taking this case up is a really big deal. And a lot of people don't get it. And a lot of people are not paying attention to how significant this is. I mean, Louisiana, I mean, look, Jeff Landry, I would argue, is probably the most consequential governor to come along for change in Louisiana. We all know that we've needed to change our Napoleonic Code and Louisiana as a whole. We've been stuck in a rut. We've been losing. We know we need to change, but it's almost like we don't know how to change. We elect a governor that runs on change. He is pissing off all kinds of people in the first session. We've got a legislature, including Seabass and some of the others, that are doing a lot of crazy crap that we all don't know whether it's right, wrong, or what, but it's change. And here we are today with a law that's been in at least since the 1800s that is having an adverse effect. That's my words. And we've got the Louisiana Supreme Court considering a change.
The Supremes.
So, what is this case about? Go to the next cut, the original brief of applicant. And basically, here's what happened. And this is something that, and I'm going to I'm going to simplify this thing really easy. I don't agree with you, Ryan Haygood, and here's why I'm not going to agree with you. And I'm going to make the point with this whole case here. You're going to see. This case began out of a basic car wreck. Okay, how many of you have been in a car wreck? And how many of you have been rear-ended or hit in the side or whatever by somebody, and it's pretty clear and cut who's at fault? There's not a lot of question about the whole deal.
Okay.
And the insurance company, you work through that process and it's settled and it's over with, and voila. Well, what if there was a disagreement on damages? And let's just go to the first page. Let's read the introduction of this suit. And this is a big deal, guys. So hang in there and pay attention. The attorneys that are primary attorneys in this are local attorneys from Bossier. Joe Gregorio from Bossier, longtime attorney. J. Cole Sarton, from Shreveport, longtime attorney around here. You've got Alan Seaball, which goes to the why I'm wearing my hat, Seabiscuit. And, one of his partners, Michael Mellering, who has been on one of our shows.
Yeah, that name rings a bell.
He's a law partner of Alan Seaball. He participated in the debate we had for the Bessie seat, but as a lot of you know, he ended up running for the state representative seat. Was it Alan Seaball's seat? I think it was Alan Seaball's seat.
I think so, but it's been a little bit.
And then his wife ran for the Bessie seat that he vacated, which his wife formerly was on the Cypress district. So does that kind of connect the dots for y'all about Bossier and why? Anyway, so keep scrolling down. Go to the first page, the introduction.
Hold on, I think I'm there, but let me make sure. Yeah, that's the end of the first page. So shall we go to the table of contents and pass that?
Yes.
Okay, that would actually be, sorry. Whoop, I think I passed it. Here we go. Introduction.
I can't read it, so you're going to have to. I guess.
Yeah, that's okay. This case presents a res nova issue concerning the constitutionality of Louisiana Revised Statute 13:4163 that provides a mechanism for a legislator or legislative employee to, at his or her own discretion, obtain a peremptory continuance of any court hearing or an extension of any deadline within 30 days prior to any legislative session or constitutional convention, 30 days after the adjournment sine die of any legislative session or constitutional convention, or any time such person is, quote, is engaged in activities including travel in connection with or ordered by, number one, the legislature, number two, any legislative committee or subcommittee appointed by the president of the Senate or the Speaker of the House of Representatives. Number three, any committee or commission appointed by the governor or any other person authorized to make such appointments. Or number four, any constitutional convention or commission. I did not realize that this also included committees
Yes,
appointments.
sir. Absolutely. And
That's a
it
pretty big loophole.
and I'm going to jump past a lot of that because there's a lot more reading, but it basically mentions Alan Seabaugh in here. This is despite our legislature's recent and unanimous passage of Senate Bill 185, introduced by defense counsel in this litigation, Senator Alan Seabaugh, that mandated if a party or attorney opposes a motion for continuance or extension of a deadline pursuant to this section, upon motion of any party or upon its own motion, the court shall award attorney fees and costs payable to the client of the member or employee by the party or attorney who opposes such motion. So basically, that means is this past session, Alan Seabaugh, who was involved in this case, tried to pass a bill. In fact, he did get it passed. He got it passed through the House and the Senate to inflict damage to any suit or lawyers or case or anybody, any plaintiff or anybody that tried to challenge someone filing a continuance to tag them with attorney's fees. So, but specifically what I wanted to focus on was this case in general. Here, plaintiff Theresa Fisher seeks review of the district court's judgment denying her motion to declare LARS 134163 unconstitutional on its face as applied to the facts of this case. Plaintiff specifically challenged the mandatory, peremptory, and non-discretionary language of LARS 134163 that explicitly deprives the district courts of this state of any authority whatsoever to decide whether to grant or deny a legislative continuance anytime a legislator retained by either party simply files a written motion invoking his legislative privilege as follows. So basically, what they're saying is they're trying to show that there are circumstances where when a legislator files for a continuance that it's not in good faith and that it shouldn't be upheld. But current law basically leaves it the court system and the judicial system to where there's
They
there's
don't
no
have any choice.
ambiguity. They
Yeah.
got no choice.
Hmm.
And so let me pose this question to all of you. If all of you were in some situation, some legal situation or legal shenanigan, can you think of some circumstance where um, a continuance wouldn't be appropriate or where it shouldn't be applicable? Is there any circumstance that comes to mind that maybe it shouldn't be able to be used?
Well, I can
Or,
think of
or
many cases where continuances have been used and abused. I I'm not going to mention names, but I can specifically think of one at the 26 JDC right now that has been continued like 7 or 8 times by the DA's office, and their excuse is they're not prepared. So, Duke, if you or I showed up for a court case and our attorney says, "Gosh, Judge, I'm just not prepared. Can I please have a continuance?" Do you think that the judge would grant that continuance to you or I, and if we had a
Well,
case?
well, that's a little bit different than what we're talking about tonight, but
I know, but
I feel
the gist of it is the sort of the
I
same.
feel where you're going. Now I want you to
Okay.
jump to the original brief of applicant file,
All right.
and
Give
the
me a second.
right out of the gate on the first page is everybody. Are y'all with us so far?
Well, now that was the original brief of applicant file.
Oh
Make
yeah,
sure
yeah, yeah, yeah. I'm sorry. I'm sorry. I'm sorry. I'm sorry.
that's okay.
The next one. So so you have this case where this person was in a car wreck, right? And you had uh, a person was hit by somebody else, and they have
Yes.
insurance. The person who was hit had his insurance, and you've got a case where um, continuances are filed, and this case just keeps dragging on,
Hey, wait
dragging
a minute.
on, dragging on, and dragging on.
Wait a minute. Isn't your buddy Seabiscuit and Mellorin, aren't they attorneys for the insurance companies?
Maybe, yeah. I've heard that rumor. I have.
And it's not a rumor, it's on their damn website.
Okay, so look, here's the thing. I saw a media release about this, and I started digging into it, and so then I went to digging on some of these filings, and there there's actually quite a few briefs to go through here, and I went and started going through all this, and I'm trying to put this together. And by all means, if Michael, if you or Alan or any of the other legislators that we're going to talk about here, or even Mr. Gregorio, if any of y'all want to come in and chime in and correct us, because we're not lawyers, we are amateur journalists, and we are piss poor journalists at that. We could get a lot of this wrong, but if we do, I mean, if we, y'all can correct us by all means, but I'm going to do my best to articulate how I perceive it. So, uh, there was a car wreck. A guy hits this lady. They want to resolve it. They can't resolve it. And why can't they resolve it? Because they can't go to court. The insurance company doesn't want to resolve it. They're disputing what's going on, and it
The,
can't get to court
the
because
insurance company is disputing it. Is that what I
one of
heard
the
correctly?
one of one of the attorneys who happens to be a legislator keeps filing legislative continuances, and this thing drags out for I think almost 3 years, if I'm reading correctly, almost 3 years. Now, here's what's interesting. This is where, are you on the second? Yeah, you're on the second one, Stephen Harder brief.
Yes, yes.
Now, here's where it gets interesting for you, those of you watching. Stephen Harder, this is the brief from the person who hit the person. This was the
All right.
person.
Hold that thought for 1 second. Hold that
Okay.
thought. Because just to prove that I was not wrong, the attorneys at Seabaugh and Sepulvedo provide fully integrated representation for their clients across a range of legal fields. Our firm is committed to working hand in hand with its clients to achieve two things. Blah 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 blah. With offices in Shreveport and Baton Rouge, we offer a full range of legal services with experience in insurance defense, oil, gas, and energy, and so on and so forth. So I'm not crazy about that. All right,
I
let's
I
go.
think they also specialize in Islamic law, if I remember correctly. I may be wrong on that one. I don't know for sure. But
Okay.
either way, so this brief right here, Stephen Harder, this was I don't know if this is the guy that hit the person, who is in the suit, the woman who is in this suit or what have you, but Stephen Harder, he files this brief, right?
He does. But I got to hold on. I'm sorry, Duke. I've gotta. This is the graphic on Seaball's website. Notice the insurance defense right there. They literally have a graphic shaking hands with the insurance company. Our firm provides robust and cost-effective defense for local, national, and international insurers. And look, I realize insurance companies need legal representation. I'm not saying they don't. But I just want everybody to remember where the deck is stacked. Okay, sorry.
Okay. Well, this case is so bad that the person who hit the other person in the car, or that side, the defendant side, they file a brief in support of the plaintiff on this case. I mean, they join the plaintiff in wanting the law that enables legislative continuances unconstitutional.
Wait.
Did y'all hear me?
Whoa. Say that again.
So okay, think about this. You got a car wreck. You got this
Okay.
car and you got this person that hits this car. We know who's at fault. The lady that Joe Gregorio is representing is the person who got hit. The person who hit them was, and I don't know if it was actually Stephen Harder. It may have been. Either way, the car was owned or insured by Stephen Harder or something to that effect. I don't know exactly, but I'm going to call it the Stephen Harder car. The Stephen Harder car is the one at fault who hits the lady who's filed
Okay.
this suit, right?
Right.
Well, this legislative continuance thing, the Stephen Harder car is insured by this insurance group, right? So this case is so bad that this Stephen Harder has filed a brief supporting the person that they hit in their filing of this law being unconstitutional, of this legislative continuance, because this thing has went on. Nobody has been able to get resolution for, I think I'm correct in saying, over 3 or 4 years because of the filing of legislative continuances.
Right. And again, it's been a long day. It's been a long night. The lady gets hit. The other vehicle is at fault. The other vehicle, based on what we can see in the suit right here, looks like it's insured through Stephen Harder Jr., Stephen Harder Sr., and the Hanover Insurance Group. It's continuance after continuance after continuance, apparently by Alan Seaball and Michael Mellerin.
Go to page
Okay.
4.
Okay.
Keep
And you're saying that Stephen Harder and Stephen Harder Sr. and the Hanover Insurance Group filed a brief in support of the woman to get this case resolved because they actually want to pay out?
Well, to find the legislative continuance thing
Okay.
unconstitutional.
Okay.
Go to
Wanted to
page
make sure I was
4.
clear. All right. 1, 2,
Yeah. How
3.
odd is that for them to weigh in?
Okay. Page 4. I'm
So
at the introduction.
the unique procedural posture of the matter at issue before the honorable court makes for strange bedfellows. For the reason hereinafter set forth, defendant respondent Stephen Harder Sr. joins with the plaintiff applicant Theresa Fisher in seeking a judgment declaring RS 134163 unconstitutional on its face and as applied to the facts of this case. Basically, they're saying they agree that this legislative continuance is unconstitutional.
Some shenanigans going on.
This is unconstitutional. Go to page 6 and 7 on this deal.
Okay. Page 6.
Okay. So basically, this is describing the. You sure this is page 6?
It's page 6 of 10 of the PDF page numbers, but
Yeah, the PDF page numbers. Okay. Well,
anyway, let me make sure. Sorry.
all right. So we can let's jump forward a little bit.
Right.
We'll move forward from this. But it would be one thing if this was the only circumstance where, and I'm not trying to minimize this case. I'm not trying to minimize this case at all, but it would be one thing if this were the only circumstance where this legislative continuance issue was a problem. If you will go to the next brief that was filed, Carly Maggett brief, there someone filed another brief in this case. And if you'll go to the introduction in this one, and we'll read that, and then we'll go to page 9, and this one gets down to something that's pretty basic regarding all of our rights as citizens, that from the Constitution of the United States. Go ahead and read that introduction.
Okay, so it says this court has granted the writ of supervisory review of Theresa Fisher, challenging the constitutionality of 13:4163, which provides for legislative continuances in judicial proceedings. Carly Maggett writes as amicus curiae to provide this court with further context into the use and abuse of the statute in question. Carly's matter involved a breakup between two people who had been dating for several years and ultimately were engaged to be married. The legal issue involved an engagement ring and debt occurred during the relationship. Jeremy Ducote filed a petition for declaratory judgment injunctive relief in TRO on June 25th of 2019. Carly filed an answer. A bench trial was originally scheduled for June 23rd, 2020, but was continued pursuant to the legislative continuance statute under review, 13:4163. The trial was ultimately held on November 30th, 2022, and January 6, 2023, which trial resulted in a judgment in favor of Carly and against Jeremy for money damages. So, what's that, 4 years later? Almost 4 years?
Yeah.
3.5. During the 3.5 years of litigation, counsel for Jeremy Ducote filed an ex parte motion for legislative continuance and extension 9 times in the district court and once in appellate court. These continuances, which are by statute peremptory and granted without hearing or consideration of any other factors, delayed the trial for 2.5 years, increased litigation costs, imagine that, clogged the court's docket, cost the clerk of court presumably hundreds of dollars in filing fees, and added to Carly Maggett's emotional pain. How did it cost the clerk of court filing fees?
Oh, who knows? Who knows?
I was going to say, that's the way the clerk of court makes their money, but that's a whole other thing. Unfortunately, Carly's experience is not unique. The Fisher matter currently under review is a great example of delayed justice and prolonged anguish. Now is the opportunity for this court to examine 13:4163 in the context of its improper use to manipulate and gain an unfair advantage in litigation. Okay. How much more do you want me to read?
That's it. Jump to page 9.
Okay. Let's see here.
So in page 9, it wouldn't be that, again, like I said earlier, that if this one case or even that circumstance that was just read to you, keep going, that's not it. News reports of abuse in the criminal context. 9 on the PDF. So
all right, so that is 9, but just tell me when you want me to stop. I'm going backwards.
9 of 12.
Right there.
Yep. All right. So listen closely to this circumstance, and I want y'all to. I'm not in this particular case because this is an ongoing case, and I'm not suggesting innocence or guilt either way. But what I am saying is that every single person watching the show, if you are charged with a crime, you have you allegedly have rights, to certain legal proceedings. You have rights. So let me just read this to you. The Fisher and Dakota cases are just two examples of abuse of the legislative continuance statute. But unfortunately, abuse of this statute is not confined to civil litigation. Another example has recently come to light involving Baron Bailey. A Webster Parish man has been held in jail presently in solitary confinement since July of 2019 on charges of second-degree murder and first-degree feticide. Mr. Bailey is being denied his constitutional right to a trial by jury because his lawyer, Senator Katrina Jackson, is constantly using the legislative continuance statute, according to the recent news report. Assistant District Attorney Hugo Holland said, quote, "I cannot get it to trial because the defense attorney is constantly using the legislative continuance statute." There's quite a few other quotes. KTBS 3 actually did a really good story on this. And, you had this, the circumstances, as I understand it, were that you had this lady who was pregnant, was in a house. There was these cars that ran by. There were a bunch of shots fired. She was struck while inside of her house from somebody outside. She died, and the baby died. This guy Bailey, I think that was his name, Bailey, is said to have been supposedly the shooter or the guy that murdered them, although he contends he's innocent. He was not the person who did the shooting, and he has sought to have an expedient trial, but has been unable to have a trial. He retained an attorney who happened to be a legislator, and according to the KTBS article, him and maybe his family spent $40,000 to this legislative attorney up front to represent them, and all they have gotten, basically, as I understand it, is legislative continuance after legislative continuance. This was 2019.
Yeah, he he said here he's partly blaming the police, the judicial system, and the prosecution. Mainly, he's frustrated with his legal counsel. That's crazy.
Yeah. So whether there has been an abuse or not, what I could say is that if any one of you were accused of, a crime like this, and, the you're guaranteed a speedy trial.
Well, but that
But
depends on how you define speedy trial
you're
or
you're
who
only
defines it.
you're only guaranteed that if there's not a lawyer involved who is a legislator. And so basically the moral of the story is that a legislator's um, concerns are more important than the basic rights of all citizens, regardless. That supersedes all your rights. I mean, and it goes to this whole show, what we were talking about from the start of this show about
Well,
government in general.
this particular guy may be guilty, he may be innocent, but he expects and has a right to due process in a timely manner.
Yeah. So you've got this court case that's going to come before the Louisiana Supreme Court that are going to hear this. And, you've got cases where, with examples of, with Alan Seaball and Michael Mellerin, filing continuances regarding a basic car wreck, and delay after delay, to where even the freaking guy who caused the accident or hit the other person is siding with the person, saying that there's an abuse here, basically. Then you've got a circumstance where you've got a criminal situation where a person's life is, I mean, this guy could potentially go to the electric chair or whatever. I mean, this guy
Well,
could be
all
on
right,
death row.
but
I mean,
let's look at
but
the
let
flip side to this. Let's look at the
okay.
reason that statute was enacted in the first place. And if memory serves me, so I'm just talking off the cuff right here, y'all can excoriate me or correct me in the comments, or Duke, you may know the answer to this. The reason that that law was enacted in the first place was because I would guess it back in the day, one of the ways to stop things from getting enacted in the legislature was to just have somebody arrested. Now,
I,
you would say, well, that would never happen today. Yeah, right. So I'm just playing devil's advocate for a minute. I do see some justification for at least the original intent for the statute, but when it gets abused like anything else, needs to be done something done about it.
yeah, I would agree. Now, interestingly, now that this case is going to be being heard before the Supreme Court on Friday of this week, Rex, you got the term limits case being heard on Friday, but you've
Mm,
also got this case being heard by the Louisiana Supreme Court on Friday. But interestingly, regarding this case in Webster Parish and this murder deal,
mm,
um, sources have told me that that legislative attorney is no longer the attorney for this person. That they are, I don't know whether they backed out, they recused, or whether they backed out, or how that happened. But I just what I'm being told that all of a
mm.
sudden, because of the light that's being shined on all of this as a result of this, this Supreme Court case, that she's no longer representing that client in Webster.
Ah, you're getting text messages of how wrong I am.
Somebody corrected me. This is being heard on Thursday, not Friday.
Which case?
This case,
Okay,
actually,
on
I
Thursday,
thought it
not
was.
Friday.
I thought both of these cases were on Friday, but somebody corrected me. Obviously, somebody's in tune.
Yeah.
Um,
Okay.
you
All
know,
right.
but the bottom
So,
line is, but there's another interesting twist or two to this. Where do you think all the legislators are on this?
well, I would say well, since a large percentage of them are attorneys, and that goes to goes to Colonel Crockett's question. So why are we electing politicians who are lawyers? Because they're the ones
Well,
running.
well, I'm just wondering, all of y'all watching the show, do you think that your legislator is in favor of putting their self-interest ahead of uh, people's rights to a speedy trial? Do you think they feel that way? I'm just wondering what y'all think. Y'all think that's the way they would view it?
Good question. Maybe one
Well,
of them will come on. Paging Alan
well,
Seaball. Paging
well,
Seabiscuit.
maybe you will go to maybe you'll go to the cut legislators briefs, because I would inform you that there is a group of legislators that filed a brief uh, against I'm saying against, but there's a group of legislators that filed a brief,
Oh,
and
really?
yeah, they're in support of legislative continuances.
Well,
And
imagine that.
scroll on down. You see right there, you
Self-serving.
see members of the legislature in opposition to the plaintiffs. So keep on going down and let's look at all the legislators.
Wow. Let me scroll. I got to scroll back on wait. Right off the bat, Raymond Cruz.
Raymond is in the house. Now, Raymond's no lawyer. Why is it that Raymond would sign up to deny a person who is charged with murder in solitary confinement the right to a speedy trial when he claims that he's innocent?
Good
I mean,
question.
does he not have rights? I'm just wondering whether he's guilty or not. I mean, if the law applies equally, and there, that scale and balance that's in the hands, if that means anything, shouldn't that person be able to have a speedy trial? I mean, what is speedy to these legislators? I mean, and I'm not making no friends by being critical of them here for all sign or name. The ones that are lawyers, I can see them
Yeah, but
all.
he's no lawyer. He wasn't he a B-52 pilot?
That's right. It's the
Okay.
ones that are not lawyers is who I have the beef with. That's the ones that I have the beef. Why are their names on here? Why did they sign it? I would love to
Yeah.
know why Raymond Cruz believes that if you're accused of murder, that you should not have a speedy trial if you so choose.
Pilot to bombardier. Pilot to bombardier. We need to know why you signed on to this.
Just saying. I you know, I I, I don't get it. I mean, I no,
Not,
I
nothing.
personally I get it.
Yeah. Nothing ceases to amaze us. Well, nothing has ceased to amaze us for a long time.
But it's all who we elected, and the AG's office, they put a brief in opposition and wanting to continue the thing. But here's the deal.
Wait,
So
whoa,
when
whoa, whoa,
all
whoa, whoa. So the AG's office is in support of the existing statute?
correct,
Okay.
correct.
Hmm. Maybe we need
Yeah,
to have the
Liz
AG on.
Morrell,
Yes.
we may
Back
need
on.
to. Um so
And again, I want to state, because I know I'm right if I remember back in my civics class, the reason for that. And that's how I kind of already knew about it, but I wasn't sure of the statute and all that, was because that privilege or that had been abused in the past, and that was the reason for passing that.
I had somebody text me to say that Raymond Cruz is pro insurance at all cost.
But that's not really pro. I mean, it is in the case of Seaball and Mellerin, and that one case that we, the main case that we looked at. But it's not just about insurance.
Well, it's not, but I mean, I don't think they care about any other circumstance other than the insurance. They could care less.
Probably so. Probably so. All right.
There was another important point that I wanted to make on this subject, and to get out there, but the bottom line is this is a pretty important case, and in these cases, whether it was abuse of the legislative continuance or not, there's other questions about whether or not this um, it encroaches on powers, the powers of the judicial versus the legislative. I mean, think about it. The legislature gets to make the rules, and the judiciary is supposed to enforce those rules. And then here they're making a rule. You've got a conflict a little bit here. Um, think about the fact that uh, this case was happening, and Alan Seaball introduced a bill in the legislature to try to uh, I hate to say discipline, that's the wrong word, but to cause there to be consequences, that if anybody opposed uh, someone opposing a legislative continuance, they would have to pay attorney fees and or more.
Yeah.
And
Kind of that
that
chilling
bill
effect.
that bill passed the House and the Senate, and it was only stopped because Governor Jeff Landry vetoed it. That was the
And,
only reason it was stopped.
and he's a lawyer.
And he's a lawyer. So the the point is
That's what I don't get. I understand. Well, the AG is elected, but she was in the Attorney General's office with Jeff Landry. So how does she square supporting the original statute. I agree with Colonel Crockett. It should allow limited continuances at best. But how does the AG's office square with siding with the original statute while Landry's vetoing the bill that puts more teeth in it for Seaball? I mean, I know they're independent branches. I get it.
Yeah, I don't know, but what I can tell you is that in my opinion that there appears to have been abuses and using the continuances, not for the benefit of the clients. I mean, if it were for the benefit of the clients, why would you have the defendant in this case, Stephen Harder, filing a brief in support of the plaintiff? I mean, if that's not the case, why would you have that happen?
Yeah,
I mean, it's clear cut.
I don't know.
But the fact, but even more important is the fact that the Louisiana Supreme Court is even hearing this case. That is a hurdle that is that is something of a magnitude that's unbelievable. And word is that a bunch of these legislators intend to show up and be seated there at the Louisiana Supreme Court when they're hearing arguments on this case. Why are they showing up? Or do they
wonder if they'll be boisterous.
I'm wondering if they're trying to intimidate the justices.
I don't know.
Is that what their intent is?
I wonder if they'll get 3 minutes to speak.
Are they going to make legislation after this specifically to rein in the Louisiana Supreme Court? Is that what they're going to do?
Those rogue Supreme Court judges.